to grant exceptions for changes to the minimum lot area and/or the elimination of the street frontage requirement for a lot owned by a public entity or a public or private utility. Mr. Ryan Harvey, a policy analyst for the council, will lead this discussion.
Thank you, Mr. Miller. Members of council, I'm going to give a brief presentation here. This was heard by the Planning Commission at their last meeting in August, and since then we've had a little time to review it, and I sent council staff report in your materials, so I'll kind of briefly go over that as well as an update because we had a meeting earlier today. The purpose of the proposal, there's kind of two purposes. You have the street frontage requirement, adding that to the code, the exception for street frontage requirement. And the second part of it is giving Planning Commission authority to grant the exception. As it is right now, if they want to get an exception to street frontage or to a lot area, they have to get a variance through the Board of Adjustments. So that's what the purpose of this proposal is. The application was submitted by Questar Gas. You can kind of see the location here. They actually want to build a building right in there and just behind that building there. And so the application is kind of based on that. You can see there's no street frontage there, but you can access the building. So that's kind of what their application is. Stated in their application, the reason for asking for this text amendment rather than just going straight to the Board of Adjustments and getting their variance. They listed a few things, but a few of them I pointed out here. Public utility facilities must be located near the pipelines or transmission lines, which serve an area with the relevant utility. Second, many times the most cost-efficient location for a facility is near the back of a property with no street frontage, as is the case here. Then third, there are instances where a property owner is willing to sell a small parcel of land, but not willing to meet the frontage requirements. However, there are easements in place that make it accessible. So those are the reasons that they listed in their application. I'll come back to this slide. The Planning Commission first heard this item in July. I think it was July 23rd was their meeting. And the Planning Commission actually recommended denial. And so the Planning Commission, I think I said the Community Development recommended denial. The Planning Commission asked them if they could reword a few things and come back with another proposal. So that's what Community Development did, and on August 27th, a vote of 6-0, they recommended approval of the updated language. In that meeting, though, they asked if Public Works still had any objections, and the only representative from Public Works that was at that meeting hadn't been dealing with this project, and so as part of their recommendation, they asked that Public Works get with the council staff to express any concerns that they may still have. And so they included that in their motion at that August meeting. So as we looked at it as a staff, together with our council attorney, there were a couple issues. The main issue being how it was worded. Essentially, the way that the language is worded is, we'll grant this exception, that the Planning Commission will have the authority to grant an exception based on three things. First being the parcel is used exclusively for public purposes, including no living quarters. Second, a lot or parcel has sufficient access granted through a recorded easement or other acceptable agreement. And then the third one was the Planning Commission finds that no suitable alternative exists for location of and or access to the proposed use. And this is where we really kind of saw a problem, that it was very vague. that there was no suitable alternative, and that there weren't specific standards set in place for granting this exception. The way that the Board of Adjustment works is they have very strict, specific criteria if they're going to grant a variance. And so this kind of vague language kind of drew some red flags. So going back to the recommendation from the Community Development and Public Works, as we talked with them this afternoon, Public Works still has some major concerns, and it deals a lot with the concerns that we have as well. The language is very vague, and it would be nice if there were some specific standards that the Planning Commission can go by, specifically so that the Planning Commission doesn't feel like they're bound to accept a project that they don't feel very comfortable with. We don't want to put them in that kind of position. And so we talked about that with Community Development today, and they suggested that we continue this item for 2 weeks while Community Development and Public Works get together and see if there are some specific standards that they could add to that Part 3 of the proposed language. And then if there was some acceptable language that Public Works felt comfortable with, that Community Development felt comfortable with, then in 2 weeks, coming back to it, revisiting it, and actually sending it back to the Planning Commission for review. If over the 2 weeks they're not able to find language that they feel comfortable with, then they would recommend denial. So the alternatives, and I apologize for the formatting there, but so essentially what you can do is you can accept the proposal as is, as was recommended by the Planning Commission, and that would again allow the Planning Commission to grant these exceptions, not necessarily a variance, but exception to minimum lot area as well as the street frontage requirement, or do as the council staff feels would probably be best, as well as the Public Works and Community Development. Continue the item 2 weeks, and then if there is appropriate language that we feel comfortable with, that you feel comfortable with, and that we would then refer it back to the Planning Commission to make a recommendation to you again. Or the third alternative is to just deny the request altogether. So I can answer any questions. Brian Maxfield from Community Development is here. Dave Decker and Dave Graves from Public Works are here. They don't have a presentation, but they're willing to answer any questions, as well as myself and our other members of staff. I think
Mr.
Brian.
Jones.
Mr. Chair and council members, one comment, Ryan's presentation was spot on about what we talked about, but with regard to the very last item about possibly referring it back to the Planning Commission, one of the reasons why we talked about that in our group was, if you look at the two proposals in front of you, the one from Questar has language in it that essentially says, I had it here in front of me a second ago, that a lot owned by a public utility will not be required to have frontage so long as there's sufficient access. So it starts out premised on this policy consideration that the only reason you need frontage is for access, right? And so as long as that policy consideration has been met, you have to waive the requirement for frontage, right? Then you've got the Planning Commission's proposal, which on the other hand says we won't grant the exception unless there's no suitable alternative. That seems to be premised on a policy consideration that frontage is absolutely essential and it should only be waived in circumstances where there's no other choice but to waive it. As we sat as a group and talked about it, we kind of asked ourselves the question, well, what are the policy considerations for requiring frontage? What are the policy motives for requiring frontage? And we came up with a whole bunch of hypotheticals and no answers. And so one of the things that we talked about in our group was, if there's going to be specific criteria defined, our recommendation would be that those criteria be linked to the policy considerations for why frontage is important, And so our thought was, well, the council is ultimately the policy setters. They could spend some time debating what the policy considerations for requiring frontage are. But why not refer it to the experts? Why not send it back to the Planning Commission and say, when you come back to us, we'd like you to tell us what you think the policy considerations behind requiring street frontage are. And then as a council, you can review those and add to them or take away from them or approve them as is. But that was one of the reasons why we thought about, as a group, sending it back to the Planning Commission, was because of that issue of not having any clarity on what the underlying policy for the rule is in the first place. So.
Thank you for that addition.
And Mr. Miller, and just anecdotally, I sent out feelers to members of the Utah chapter of American Planning Association on that very question, what is the premise? And it was interesting, of the two responses I received, both were, one planner felt there was no need for frontage, the other planner thought it was very essential. And so, not that I only share that to say that I think it would be warranted to identify the policy reasons for the standard.
Questions, please, of Mr. Harvey or the other gentleman to whom he referred. Mr. Winterton?
Just offhand, do we have many, we talk about Questar, we have our own Provo City Utilities, how many other entities? Do we have a lot of other entities that own property that would get to the point that they don't need to worry about frontage should we pass something like this? What are the other entities that we'd be dealing with? AT&T, all the telecommunication, so we could end up with huts if we want, anywhere in the city if there's no requirement for frontage on that type of situation. And in the meantime, they do just have to go to get a variance if that's what the policy's been in the past.
Yeah, that's what it is right
Mr. Winterton, I think you hit on a point, though. Why, and this is another policy consideration, why are public utilities granted an exemption versus everyone else? And that's something I think remains unanswered as well. And hopefully this discussion about what's the policy objectives around frontage can help answer that question as well.
In fact, that reminds me, if I may, one other discussion point, which was that we may want to consider what the unintended consequences of the policy are, because just because a property is acquired by a public utility doesn't mean it will forever be owned by the public utility. So if you create a lot with no street frontage, so if there is a compelling policy reason for exempting public utilities but not exempting anybody else, one of the things we discussed was consider the fact that maybe 50 years from now the public utility doesn't own the lot that has no street frontage anymore. And does that change the calculus about whether it should have been granted in the first place or not?
Yeah, and another policy question to add to that was also in the report is by one of the concerns that Public Works brought up is by putting street frontage in there is, because right now it's not in the ordinance and it's just known that if you want to get a variance you go to the Board of Adjustments, but by putting it in there are now all the utilities going to find ways to try to get that exception instead of trying to abide by the code first. So it could open up that as well.
The document in front of me reads not just public or private utility, but also any public entity. Is that the case? We've just been talking utilities.
Yeah, that's the language in there. I mean, public entity, I don't know where we...
Well, and if I don't have the ordinance open to me at this moment, but that's an undefined term that, if we, at a minimum, ought to define what that means.
Yeah. It does say public.
Part of the current proposal, but yeah. So the problem is, I think, with the phrase "public entity" is then who does the standard apply to? Public entity is a pretty vast array of organizations, or potentially, arguably, does that include nonprofits? Does it include, who does that include?
So that could also be.
Would you comment further on the motivation here? Why is the Planning Commission looking to possess this kind of exception-granting authority, and it would seem thus bypassing the Board of Adjustment?
Yeah, so, and Brian Maxwell, do you want to comment on that? Because you brought that up.
If I could answer that quickly, Section 1507, Title 15, which is more the subdivision, it specifies variances actually go to the Planning Commission for variations to 15. And so the thought was dealing with site plans, dealing with subdivision, site plan issues, that was more proper in following Section 1507, which currently directs to the Planning Commission rather than Board of Adjustment.
So our practice of referring such matters or applicants to the Board of Adjustment is misplaced.
No, because that, dealing with house location and other situations is really Title 14. There's a difference on putting the structure on the ground versus lot creation. Yeah, and that's kind of probably where the confusion is. They felt that because that's related to subdivision, and 15 handles subdivisions normally.
So it's a way of somehow...
That's the anomaly, is that 14 is dealing with the subdivision. So they say, why not bring that back and do the same thing?
Well, I think we're talking about two different standards. One, there's subdivision regulations. There's also lot regulations, which are Title 14. So how you design the size, the width, the depth of a lot is regulated by Title 14.
Right.
Has always been handled by the Board of Adjustment.
Right, and that kind of a title, but lot creation itself is the 15 one, and that's, I think, what they were feeling it fit better in.
Lot location?
Lot creation.
Creation.
Thank you for that clarification. Other questions?
I might respond to just to elaborate on this idea of why the Planning Commission would want this exception authority. I don't think it's highly unusual for the Planning Commission to have such authority in other instances of city code. And it's another vehicle to possibly deliver exceptions in the Board of Adjustment. I can't cite a list off the top of my head, but the Planning Commission does have a number of ordinances where here's standard A, but here's standard B if X, Y, and Z are satisfied. And that happens fairly frequently in the under the authority of the Planning Commission. And I think that this proposal is more akin to here's standard A, here's standard B if, which provides a different set, almost a tailored set of criteria per circumstance, whatever you're dealing with. Whereas the Board of Adjustment is very narrowly defined to granting numerical deviations to standards, lot size, square footage, setbacks. And to grant one of those deviations, you have to meet 5 specific criteria as outlined by the state. And so there are 2 mechanisms for 2 separate purposes. And so I wouldn't think it's unusual for the Planning Commission to go this route.
Mr.
I'd
Hales,
like to
please.
make a motion, if appropriate, that we allow 2 weeks' time for these 2 entities that have mentioned in the city to converse, to come up with additional language, after which that would be referred back to the Planning Commission for review and then forward to us.
A second.
I'll second the motion.
Thank you very much, Mr. Garrett. Discussion of the motion. Very well. All in favor, please vote. Thank you. The matter passes unanimously. This item will be continued until the 21st of October. Mr. Taylor, we now take up a resolution denying an annexation petition for further consideration for 53 acres of property generally located east of 5068 North Canyon Road, Provo, in the North Timpview neighborhood. And Bill, please, in your introduction to the matter, provide some situating context. For this
Absolutely.
issue.
I apologize, I did not create a map for your review. To describe where this is at, other than the address, the property obviously is unincorporated. It is a portion of what you previously considered for annexation earlier in the year, but couldn't grant because of the state statutory requirements around islands and peninsulas. This is the southern portion of that previous proposal. My understanding, although indirectly, is that it is tied in part to a future development of incorporated undeveloped property just south of it, possibly by Ivory Homes. So the southern portion of the annexation would be part of that development. The northern part, my understanding is that the intent would remain agricultural for the time being, and that the property owner has no intent at this time to develop it. The reason it was noticed in this way, and we probably should have noticed a resolution accepting or denying that would give you more latitude. However, I do think it's in the best interest to recommend that we would recommend denial of the petition, and here's some statements why. Now, if you can rotate, you see the north. There you go. So on the bottom left is the Canyon Road, where the dark border is. So the state statute requires that within 14 days of receiving an annexation petition, that the council must affirmatively accept or deny the petition for further consideration. So at this point, you are not granting or approving anything. You're simply acknowledging the receipt and determining whether it's worth further consideration. And the reason that I think the state gives you that latitude of denying it for further consideration is that if it doesn't have merit for some reason, that you're not even interested in talking about it, or maybe it's outside your annexation policy plan. In this case, the recommendation that we said deny the petition is that the petition was not accompanied by other statutorily required items per city code. In the case of Title 1503-300, which is your preliminary plan guidelines, requires that any request to rezone or annex property, a preliminary project development plan shall be submitted to the city, which this requirement has not occurred. So you've not received the preliminary plan in conjunction with the petition. Further, there are some additional requirements under the annexation statute in Title 1515 requiring some additional information about water rights and their use, which also has not been submitted. So based on those two deficiencies in the submittal, the recommendation for denying the petition is before you. If you do not, now the reason you need to act affirmatively, though, is after 14 days, if you do not act affirmatively, it is deemed accepted. That means you have to put a lot of time and resources into something that you're not prepared to address, or you don't have sufficient documentation in this case to address, or potentially you don't even want to address. So that's the reason for this affirmative action by the state. Determine if you want to address it or not.
Thank you. Are there questions of Mr. Taylor about the matter, or Mr. Jones?
I understand that in the past we've had troubles with the island issues, and this actually will not affect that.
No.
As far as bringing it into the city, should we at some point want to do that? Is that correct, Mr. Jones? This will actually minimize the challenge that we've had in the past.
Well, I haven't, that's what I've also been told. I'm not sure what's county property on this map, and this is the only map that I've seen. But
Everything within the boundary is county property. Short of doing the actual calculations of dimensional standards as required by the state, I can't 100% say for certain that it would eliminate the peninsula issue.
It
Mr.
doesn't
Maxfield
completely
suggested that
eliminate it,
maybe they'd have to cut it off a little bit further into the property.
Mr. Maxfield?
Thank you. See, make sure. There's a question on the peninsula where you could define that peninsula as extending to these corners as the shortest distance. This other area, this is all county area out through here, if you can imagine where that goes. It includes the areas that we, looked at earlier on the other annexation proposal. And so by including this, you're starting to extend out into that other county area. It would be, even with the border. But if you did a strict interpretation, some line across here down this other area would seemingly get rid of this part of the peninsula. And that's kind of the break on the two.
That's part of the process subsequent to accepting it that we would go through to determine compliance with those standards. One thing I failed to mention about the preliminary plan is its intended purpose is to help you evaluate the merits of the annexation as well. Sorry.
Ms. Santiago?
The Loveless property, they have not signed the petition, is that correct?
That's correct.
And so does that make them an island there?
No, basically you'd be forced to annex them in if you accept the petition.
They would be forced to?
Yes.
Okay.
Mr. Jones, do I understand correctly that our reasons for denying this particular application would be different than those on which we, or by which we denied the previous application?
Yes, and to reiterate what Matt has said, you're essentially kind of short-circuiting the process. You're not actually, so at this step, I was going to try to put it a different way than Matt said it, but I think I'm just repeating him. But at this step, the recommendation is to deny it from further consideration. That doesn't mean that you're saying we'll never annex this. It means, in essence, you're sending a message, the application is incomplete. If you want to resubmit a completed application that meets with the statutory standards, then we'll relook at it at that time. But it doesn't trigger all of the mandatory noticing provisions under state statute that are automatically triggered after 14 days, or if you say you'll approve further consideration of it.
Thank you.
In your materials is the flow chart. I don't know if you had an opportunity to look at that flow chart. We don't have it for the screen, but it's quite an intensive process and costly from staff time and primarily to review these things. And if they haven't met our minimum statutory standards, I suppose that's the question. Why proceed?
Mr. Winterton?
Yes, and one of the concerns we had with our other annexation had to do with servicing this property. And I see Bart and Dave here. I just wondered, as I drove through that property and had the opportunity to be taken through by Mr. Smith and Mr. Brown, I didn't see a lot of challenges with servicing the property. But I don't know about the water pressures, Bart. We need your help on that. And it looked like there was enough room for good-sized roads and not steep falling off hills like we have in some parts of our city.
Yeah, there are some, but there are challenges associated with it on the whole area that we cannot service without some extensive, the developer's going to have to move some extensive lines in to get that done. There are
Even for this south part.
Yeah, no, the south part, we can service off of the current zone up to a particular level that we've given them. However, not the entire zone. And so there will have to be additional lines put in from the northeast zone coming to that from one area or another, and there's been a couple of possibilities suggested as going through a power corridor and other items, but we cannot service the entire area.
The entire area of this one or the other annexation proposal?
Both.
Both,
Yeah.
okay.
Not without additional facilities. Now, we do have this, so that we could do it with the current tanks we have, but it has to have a major additional main line taken, and there's going to have some hoops to jump through as far as how to get it there.
And will those hoops be jumped through by the city, or I guess that's what we need to be determined?
Developers going to need to do that unless I hear something different. Unless we hear something differently, the developer will have to deal with those.
And the developer would have to come through with those, okay?
Mr. Deckers, would you care to add anything?
Thank you for the opportunity to add just a little bit more comment. I think for clarification, I think the way I would describe it, the intermediate zone can service the southwest portion of the map that you're seeing up there, but once you start to climb up on the bench areas, that's where we run into trouble with pressure. So about roughly a third of that on the southwest corner could be serviced by the water. The rest of it could not be. The other items that I would caution and would come out through the process relative to annexation, if they resubmitted the annexation, obviously would have to have sewer, and it would be very similar to what the discussion was on the previous application. This particular piece does have a fairly reasonable access to sewer on Canyon Road. It's not too far away. And then also stormwater. And stormwater in this particular case is a little bit more of a challenge. Canyon Road is sloping to the south at this location, and our closest storm drain is quite, I think it's, yeah, Bart says 5,000 feet. It's quite a distance as far as stormwater, so there is a bit of a challenge to get stormwater out of the area. That's all I have.
Mr. Jones.
I don't know that this is really relevant to your consideration tonight, but just for the full scope of the discussion, I would also let you know that I've been to the last two meetings of the Land Use Task Force up in Salt Lake, which is a group comprised of Utah League of Cities and Towns representatives, city attorneys, and developers that work together on legislation. Cedar City has an annexation issue where there's some property that they really want to annex that state code prohibits them from annexing. As a result of the discussions the last two meetings, my sense is, and again, I don't know what everybody's timing is on this, but there will probably be a recommendation from ULCT to the legislature at the next session making changes to the state annexation laws. One of the things they'd really like to do, but I'm not sure if they'll be able to do, is change the definition of peninsula to something meaningful. But they're also going to be addressing this islands and peninsulas issue. So,
thank you. Mr. Garrett.
Quick follow-up question, Mr. Jones. Is the applicant held to any timeline? If this is denied by the council, do they have a period of time during which they need to bring the missing materials back to the council?
No, this denial basically says this application has been rejected for consideration. We're just not we're not going to consider it at all. But they could come back with another application tomorrow, and the council would have 14 days to decide whether to consider that application or deny it again.
As I look at our general plan for this area, right now I believe that we're looking for some more residential homes in this area, and there's a spectacular place for homes. Our challenge is the servicing of those as we go forward. To me, as I look at this, I don't want to discourage this completely, because I think it's something that it'll be a benefit to our city. And so I encourage you to continue to go forward and work through the process. I'd love to start tomorrow digging a house up, building a house up there, but I think there is a process that we do need to follow, and making sure that we're doing things the right way to make sure that we're not causing ourselves problems down the road as far as servicing those that ground and making it work for everyone. We don't want to get into a position where we're putting people coming to us and saying, why don't we have water? Or why can't we get up here now? Or what are our sewer systems problems? Brian, I'm sorry, did you?
Just to make you aware, we do have at our Coordinated Review Committee meeting tomorrow, we are meeting with the developers on the south end of this project, which will probably lead to answers to a lot of those questions. So,
Will that become part of this annexation process?
the very bottom, but
Just
it
for the
will-
bottom
it
part,
will
we're
deal
still
with
dealing with the other
services and
parts
the other-
by East Lawn and those type of
Yeah,
situations.
the upper part, it will not answer that, right? Just the lower parts.
It's not too far from your statement to a motion.
Mr. Miller, could Mr. Brown had a comment as a part of
The applicant,
the applicant.
by all means.
Council members, thank you for
You are?
bringing this. I'm Tony Brown. Thank you for bringing this to the agenda this evening. I just want to point out, if I can work this little laser here, this little strip right here is our property, 5050 North. And then the proposal says 5068 East and beyond. That's all of the remainder here, Smith's property up there. Part of the reason for submitting this proposal was because we are involved in this purchase that Mr. Taylor mentioned by Ivory Homes. They have purchased the property to the south of us, or they will be. And this is the development plan that they're working on, which then takes into consideration our property also. And it's in their interest, of course, to be able to see our 5050 North piece come in so that they can then plat the whole 19 acres to the south of us plus our 7 acres. And so I approached Stan Smith, our neighbor, just to the north of us, about resubmitting a proposal to the council to bring in the whole section here. And part of the reason for that was because we felt like it would be in the council's interest rather than to reduce the peninsula right here. And this is clearly a peninsula because the Roney property right here is city. They're an island. And so the idea was, rather than come in just with the 5050 North property, ours, that we come in with the full piece, because then we would effectively eliminate the peninsula, rather than shave off a piece of it. And it seems like that would be in the city's interest to want to be able to eliminate the whole peninsula. And so hence the full proposal, but this also has to do directly with the development of the area to the south, and our property being included in that development. So I guess I'm hesitant to see the word denial used. I would like to be able to see continuation in some way, because denial somehow has this connotation of there's something effectively wrong, but I would like to just point out that we followed the instructions on the city's forms to a T in terms of what we submitted. So this kind of came as a surprise to all of us. That for some reason, it was denied. So I wonder if we could somehow change the language somewhat and think of it as a continuation. And furthermore, that we keep it on the agenda for the 22nd with the Planning Commission. That's all. Thank you.
I wonder if we might hear from Mr. Parker on the matter of having endeavored to fit to a T the application, and then from Mr. Jones about a possibility other than denial.
It's a great question. This is again, reading the resolution was the first we were aware that the standards hadn't been fully met. Again, that was coming out of planning staff. So I'm not sure, Mr. Maxfield, if there's a sense that maybe the application form isn't currently up to date. I don't know what the standard might be that we'd missed here. I know that the resolution speaks to the issue of water, but I don't know if you want to comment on the application form.
I think that's it. I think 1515 deals with annexations, but then there's the other reference in 15, was it 03? 03 that has the preliminary plan requirement. And so I think if you read the one with the annexation and follow that down other than the water, I think that's kind of where that went instead of doing that other part. So we'll get those so there's a cross-reference for sure.
Thank you. Mr. Jones?
Unfortunately, we're at a confluence with state law, right? And so the state law says specifically that the council has 14 days to say, we're not going to consider this particular petition anymore, or if they miss the 14-day deadline, or if they say we are going to consider it, then all of the noticing provisions get triggered. And the problem with the noticing provisions is that then the city's required by state law to turn around and forward this petition on, and you've got to notice the boundary commission, and you've got to notice the county, and all of that's taking place in an absence of the documentary requirements that Mr. Taylor has just mentioned. So I think it's problematic to either continuing it is, in my mind, under state law, probably the same as approving it for further consideration, unless you continue it to a special meeting that's inside the 14-day window. Now, as an alternative, again, if we make clear that what we're doing is not denying annexation of the property, but denying further consideration of this application, I'm sure I don't know if there's a fee for submitting an application. It seems to me like the city would be within its rights to say, okay, we're denying further consideration of this application as it stands, but you can come back tomorrow and submit the same exact documents with the additional required documents attached to them, and we won't charge you another fee. And we'll get that on the agenda for, within 14 days of when you get the new packet into us, right? But I think that's still, even that, by following the state statute, I think you're technically denying further consideration today, but in whatever you say here in this public meeting, indicating your willingness to consider a resubmittal as soon as it's submitted.
And you heard that, Mr. Maxfield. Thank you. Mr. Brown, it may very well be that the term deny has the unfortunate connotations you referred to. So if we in fact vote to deny, we want you please to understand that the term is meant very narrowly and refers to what is apparently missing from an acceptable application. This is a task that the state legislature has assigned to the municipal council, which is why we're hearing it. I dare say, I better not speak on behalf of my colleagues, but I'm woefully ill-informed about all the detail for an annexation application. But it would appear to me that you're, and those whom you may represent are entirely capable of amending the application as may be needed. And I think you've heard enough from members of the council to know that it would be received with interest, certainly. Mr. Sewell?
Just wanted to echo what he just said, that it would be received with interest. This would be a great area to have more homes in Provo. So,
Mr. Winterton.
With that in mind, I would like to make the motion to deny this at this time and have the applicant get with our Public Works and finish up, and Community Development, and finish up what they deem to be lacking at this point, and please bring it back to the council.
Beginning tomorrow morning. A second, please. Thank you, Mr. Hales. All in favor? Thank you. The motion passes unanimously. Finally, we turn to Mr. Taylor once more for discussion of an ordinance amending Section 2.31.010, Redevelopment Agency Established Designated Powers of the Provo City Code to update reference to and make consistent with Utah State Code.
Mr. Chair, I defer my time to Mr. Jones.
Mr. Chair and members of the council, this comes to you because of the ongoing project that Mr. Taylor has described to you before, where we have an intern that's going through the code looking for out-of-date references. This one seemed like a fairly simple one, and we put it on right away. Within the last 2 days, though, I've had a couple of concerns expressed to me on behalf of RDA staff and the prior director, Paul Glauser, by Camille Williams from our office. What it comes down to, what it comes down to is this a really technical argument about this replacement of the name of the state act. Mr. Glauser had some concerns, and I guess this must have been discussed previously, had some concerns that there might be an interpretation of replacing the name of the act that limited the powers of the RDA to only powers listed in the new act and not in the previous act. We've talked about it in our office. We're fairly confident that that's probably not the case, and we think we have the legislative history to show that this doesn't limit the RDA's power. But as I spoke with Robert West just before this meeting, it was recommended that Mr. Glauser worked very closely with Mr. File, the RDA's outside counsel who's worked with them on many projects, who was one of the principal actors involved in passing the new Community Development and Renewal Agencies Act. So just because of that, because it's not 100% nailed down, after discussing, our recommendation would be that you continue this, and my plan would be to reach out to Mr. File and send him a copy and just make sure that he doesn't have any concerns about it.
Moreover, we were recently informed by the mayor of the appointment of a new director of the redevelopment agency who is due on the scene soon. This might be a very good matter to refer to him as well.
Sure.
It's a form of introduction to the job. I'll invite a motion then to continue this matter until the 21st. Discussion first?
No, I was just going to ask the time frame.
I'll make that motion.
Thank you, Mr. Garrett. Is there a second? Mr. Sewell, thank you. All in favor? The motion passes unanimously. Thank you. Now I invite motion, Ms. Santiago, for adjournment. And a second. Mr. Winterton, thank you. All in favor, please signify. Thank you. The motion passes unanimously.